Wait, people Lordship, I beg to mention item number 31 of today's list now.
Yes.
So in this case, the private respondent has filed an application for stay, vacation of the stay. I have received a copy yesterday. I need some time to file my.
Who is for the other side?
The other side,
Any objection?
No, no, no.
Mr.
Short time maybe.
Mr.
S. Vishwakarma.
S.
Vishwakarma.
Vishwakarma appearing for the writ petition is granted
2 weeks time.
2 weeks time to file. Written objection.
Affidavit in objection. Affidavit in objection. Opposition.
Affidavit in a position in what? In the main case?
In the I for stay with it.
Is allowed to file affidavit, is allowed to file affidavit in the IA. This is the matter after the repeating.
I should pick it maybe.
Give her 6 data.
Please, Lordship, my lord. My lord, I have mentioned memo, my lord, for listing, my lord, immediately after vacation, my lord, 119, my lord, tender matter, my lord, emergency care, my lord, motion.
Give.
My-
Your Honor, I beg to mention item number 4 and 5, kindly pass for the method for the payment.
4 and 5.
Personal difficulty of missing. 4 and 5.
4 and 5. Okay. On the prayer for adjournment made by Miss T. Soap.
S Kotopi,
Or S. Potoki. Then it but S. Potoki is not there in 5.
for 4.
Huh?
4, my lord.
4.
4, item number 4.
On the prayer for adjournment made on behalf of Miss S. Kotoki, then it also for the petitioner. List the matter
After vacation.
after vacation. What about 5?
Tiso, my lord, on behalf of Tiso.
Okay, on
Yes,
behalf
sir.
of Kiso, same.
Lordship. On the instruction of
Miss- Mr.
S. Bora.
Mr. S. Bora, learned counsel for the petitioner, submits that he has instructions to withdraw the writ petition. So accordingly, the writ petition is dismissed as withdrawn.
Well, to the Lordship, this was a matter which was pertaining to a.
Anything survive?
So, no, Lordship, as of date, Lordship, we have been instructed that our blacklisting period is over, Lordship.
So, yeah,
Our blacklisting period is over, your Lordship.
so it's
Lordship.
infractions.
Infraction, Lordship.
Mr.
N Gautam, your Lordship.
N.
Gautam,
N,
Gautam, your Lordship.
your name is not here.
Well, on behalf of Mr. J. Patwari, your Lordship.
Mr.
N Gautam on behalf of.
N. Gautam, on behalf of Mr. J. Patwari, learned counsel for the petitioner, submits that the writ petition has become infructuous. Who appears for the other side?
Also NBCC.
NBCC, who is there? All right, no one appears for the respondent. In view of this submission made by Mr. N. Gautam, the writ petition is closed, is dismissed as infructuous.
Lordship.
I is, in view of the order passed in the main case, the I is also disposed of accordingly.
My lord, petitioner is an RTI activist, my lord. He has sought for some information from the authority BDO. And
Not been given.
out of 8 queries, I have been given 5 queries and 3 queries.
Answers,
Yes,
answers to 5.
yes. And 3 questions are remain to be answered, my lord.
You
Page,
said out of 8.
out of 8. Page 25, there is an order passed.
Is
by
there
the-
any provision for execution of the order before the commission? There's nothing. Okay,
Yes.
right.
Page 25, my lord. This is the
Heard,
order.
Mr.
N. Sharma.
N. Sharma, learned counsel for the petitioner who submits that despite the order dated 20/05/2022 issued by the Assam Information Commission to the SPIO, Office of the BDO, Murkong Select Development Block at page 25, para 5. to furnish the information to the petitioner with regard to the letter dated 22/12/2021, comma. The respondent number
Three.
3 has furnished only has furnished information only with respect to 5 out of the 8 questions sent by the petitioner. First up, issue notice returnable in 4 weeks. Who accept notice on, wait,
We can accept notice on.
issue notice to the respondents number 2 and 3, only 2 and 3.
We can appear also.
Ah,
Regarding respondent number 1, notice may go.
okay, no, one, no need to go, one no need to go. Issue notice, huh?
Matter may be disposed of, my lord, directing the authority to furnish, my lord, as per the order.
No, you see, that's the same thing. If they don't, again, we'll pass an order disposing it off. And if they don't do it, then what happens? We can dispose it off to the, as per this, that's not a problem.
Yes.
Okay, right, don't say issue notice, you say, Mr. R. Talukdar appears for respondent number 2 and 3, full stop. Full stop. In view of the order dated 20/05/2022 passed by the Assam's Information Commission, comma, the respondent number
Three.
3 is directed to furnish all the information with respect to the questions asked by the petitioner. But why has he not furnished it to you? On what ground?
My lord,
Asked by the petitioner in his letter dated 22/12/2021, correct? Within a period of 2 weeks from the date of receipt of a certified copy of this order, the writ petitions accordingly disposed of. Next. Who? Sharma, your name is not here.
my lord, I on behalf of PJS.
Mr. N. Sharma.
Yes.
N. Sharma appears on behalf of, appearing on behalf of Mr. PJ Saikya, learned counsel for the petitioner, huh? See that. Okay, heard, mister? What is your name? Your name?
Cafe Ahmed.
Huh?
Cafe Ahmed.
Heard, Mr. F. A. Ahmed, learned counsel for the petitioner who submits that the order dated 22/3/22 passed in WPC 6602/2018 has not been complied with. Issue notice returnable in 4 weeks. Petitioner takes steps for service of notice upon the respondent by registered post with AD within 2 days. List the matter after 4 weeks.
Obliged.
Well, since my instruction is evident, I paid some time for file my affidavit. of speech.
Ms. J. Gogoi prays for further time to obtain instructions with respect to the contractual bills of the petitioner.
Lordship, it's a admitted amount, Lord.
Let her take.
Oh, no, that's it.
Yeah,
Actually,
you-
the-
List the
Last
matter,
week of-
list the matter on when?
2 weeks, Lordship, okay, weeks.
When? I'll give a date.
Any
Lordship 19,
8/5, 9.
19, Lordship.
No, not so far. A Bihu time, madam. No one is going to be in the office.
Lordship in the month of April.
8th of May.
obliged.
Lordship, this matter may kindly be taken up along.
Along with the others. So your case is that since it is not there in the NIT, then the rate that they have quoted will have to go. Supposing there is a difference of 1,000 kilometers, still, they'll have to, use the same rate that they had quoted. Is it? That is a basic stand.
Not that.
That cannot be. How can it be? That's totally unfair, huh?
We'll file our affidavit in opposition.
What is there to file?
My lord,
What is there to file? Anyway, how long will you take? Because everything is there in the impugned order. There's nothing, that line is there, I think.
My lord.
In the impugned order, which is that the rate quoted by them as per the
Distance.
kilometer distance given there, that will prevail. Now, if there's an actual difference of 1,000 kilometers or say 20,000 kilometers, doesn't matter, huh? That is the basic implication of your impugned letter.
And their committee find it, my lord.
I know.
Four weeks
But-
time may be granted. my lord.
What is there? Everything is there. You just have to just put this again. What is that? There's nothing. You obtain instructions, file affidavit within 3 weeks, we'll give you, okay, the most. And then we'll do, there's nothing. We have got nothing to say beyond what is stated there. Heard Mr. G.N. Sahawala, learned counsel for the petitioner who submits that the impugned order dated
My lord, this-
26
Yes.
to 2023. Passed by the respondent number. Passed by the executive director, bracket any, FCI. Should be set aside. Pusta. The petitioner's case is that they had been selected to be the carrying contractor for the FCI in pursuant to a tender notice where the distance was 292 kilometers. Full stop. However, the petitioner came to learn that the actual distance to be covered was 345 kilometers. Full stop. The petitioner had submitted his
343.2.
Huh?
343.2.
343.2 kilometers. Full stop. The petitioner had, however, submitted his bid at the rate of rupees 2,759 per MT, keeping in view the distance quoted in the NIT. Full stop. The grievance, the representation of the petitioner with regard to giving him for revising his bid
Or 340.
for 343.2 kilometers. For revising not his bid, his rate for 343.2 kilometers has been rejected by the respondents, by the impugned order. On the following grounds, I think 8.27.
My lord.
On the following grounds, on the following clause 8.27, page 162, huh? 162 and 827 and 828, 8.28, 8.27, 8.28, page 162 and 160. Just quote this, okay? Issue notice returnable in 3 weeks, Mr.
4 weeks, my lord, on 2nd of May,
Mr. What is your name?
BK Singh.
BK Singh, accept notice on behalf of all the respondents. Actually, 4 weeks, make it 4 weeks. And Mr. BK Singh shall submit his affidavit, comma, if required, within a period of 4 weeks. List the matter after 4 weeks.
Well, there is an interim PR, my lord, because security deposit is lying with them, my lord, as well as bank guarantee.
Ah.
My lord, that may be released to us, my lord, immediately.
My lord, they have to submit a no demand certificate and we will issue it.
Yes,
There is a
that may be-
procedure, my lord, they have to submit a
Yes,
no
we
demand
shall keep
certificate.
that close. My lord,
If they submit it, we
no,
will.
no demand, my lord, if this case is pending without prejudice, we shall submit, my lord.
Without.
Because the division bench also.
We'll dispose it of on the next day.
Well, division bench has directed, my lord, in one matter, my lord. Which writ petition was allowed and they filed it.
Okay. Right. In the interim, the respondent authorities are directed to release the security deposit amount of rupees 1,50,50,880. Huh?
As well as, my lord, the bank guarantee.
along with the bank guarantee amounting to rupees 4,51,52,640
Yes.
to the petitioner.
On the submission of no demand certificate.
You submit that no demand certificate. How does that?
Your losses may just seem a lot, division bench has observed, who was saying that this should be without prejudice to matter. If for on furnishing a no objection certificate, but it. will
On
be-
furnishing a no objection certificate, Rob, continue. On furnishing a no objection certificate, full stop. The above would be without prejudice to the
That's
claim of
what I
the,
was submitting, madam. No
Huh?
demand certificate without.
Claim of the
prejudice
petitioner is
to
up-
petitioner.
the above would be without prejudice to the claim of the petitioner in the present petition.
That is, my lord, be no demand certificate. No, it is not no objection certificate. No demand.
No demand, no demands.
No demand certificate. As per the tender document.
But it is no objection has been
And
given.
that
my
was
lord.
wrong. That
They were there, my lord.
Okay, no demand certificate. But then this would be without prejudice.
that-
Okay, Satyana.
that one.
Yeah, please, Your Lordship.
Yes,
Your Lordship, in this case, Your Lordship, there is a tender ordered by the respondent number 2 for distribution of the books in the different districts and places, Your Lordship. Wherein I qualified in the technical bid as well as in the financial bid L1. Thereafter, there is a reverse biddings where also I am L1.
they are what,
L1, Your Lordship.
reverse,
Auctions, Your Lordship.
It's a reverse auction.
a reverse auction.
Price keeps going down, your lordship. Both the bidders are, L1 and L2 are given an opportunity. They keep bidding lower and lower. Lowest bid finally wins.
So in both your.
So, so even in the reverse auction, you are number one, L1.
Yes, Your Lordship.
Then,
But still, Your Lordship, the.
They have given to
contract has not
somebody
been
else.
awarded To me, it is awarded to respondent number 4.
and L4 was one of the bidders,
No, yeah, he's not the one of the bidders.
but he's one of, he's a government instrumentality.
Government. Lordship, what had happened in this matter, I have not been served with a copy of the petition. So I am the primary respondent, your lordship, respondent number 2 and 3, textbook corporation. What had happened was we had initiated a tender process for distribution of free textbooks, which had to be finished before 31st of March because the academic session starts on the 1st. So we were on a strict deadline. A writ petition was filed, your lordship, before this honorable court by another bidder, your lordship. There was an interim order passed that no final order should be passed in that tender process. So textbooks were lying in our godown, which had to be completed before 31st March. So we had it done through the Assam State Warehousing Corporation, which is state instrumentality. And my instructions presently is that 98.6% of the work is complete.
How much?
98.6, it's a very precise percentage.
98.6 have been done by the warehousing corporation
And
already.
payments have also been released.
Your Lordship, in this case, Your Lordship, it's a question of unfairness, Your Lordship.
Then you file a damage suit, what is that?
Your Lordship,
Now, if 98.6, another thing, if you look at some judgments of the apex court probably, this is a contract given to a government instrumental. They are using their money.
Your Lordship, my humble submission, Your Lordship, the entire process is under the GEM portals.
Gem.
And you violated the GEM portal, Your Lordship. in the
Now,
GEM
no, Mr. Counsel, now what to do? Now, the
No.
thing is that if there is 98.6% has been completed,
Your Lordship, notice maybe you should let him produce the documents that 98% had been completed, Your Lordship.
Okay.
It's a verbal.
okay,
And in the meantime, Your Lordship, no further work, Your Lordship.
no.
Because it is total violation of the contract, Your Lordships, even the GEM portal, Your Lordship.
When was this tender given to this work order given to this person, the warehousing corporation?
This is not known to me, Your Lordships, it is given when the interim order of this honorable court was enforced.
There was a case, earlier case.
There was a
Yes.
case by another tenderer. We were asked not to finalize that tender process.
And
But
during
since-
that period,
We did not finalize the tender process, but since the textbooks had to be distributed anyways, before 31st of March, because the academic session starts on the 1st of.
So you violated this court
No,
order.
no, no.
yeah, Lordship.
Court was aware, your lordship.
Huh?
The honorable court, your lordship.
Court was aware.
Yes, it was
And
aware.
court allowed you to, according to you, court allowed you to flout its own order.
Because the tender process, your lordship, we did not finalize.
Tender process.
No, never filed.
So what was the interim order passed by the court?
Interim or I have a copy.
Your Lordship, page 49, Your Lordship. Your lordship, sorry, your lordship, page 52, your lordship.
No final decision in respect of the tender.
Your lordship.
And
And
this
on
matter is still
16th,
pending.
your lordship,
Huh?
This writ petition is still pending. It is not disposed of. This stay order was.
And so this warehousing corporation was not a party
No,
to the tender process.
your lordship.
So the tender process has come to naught.
it is in effect, it has come to now.
Naturally, you are circumventing the order.
But the honorable court, it was in session of the facts that the work, because your lordship, the reverse auction, the stay order, we were on a strict deadline, your lordship. 31st of March
So
was
that
not
you-
met, the academic session would suffer.
Your lordship, if he is so, he could have been filed application before the court, your lordship, in that.
No, that is a different issue. Now, that is in the realm of contempt.
He followed.
That is in the realm of
Your
contempt.
lordship.
That is not now, that is a different issue.
Your
Now, with regard to your case, you still want that 1.4%.
Your lordship, the order was passed.
Okay, anyway, right.
One of the order was
Right.
passed.
Alright, Mr.
Your
Eden
lordship.
Jha. Eden Jha, learned counsel for the petitioner who submits that the petitioner took part in the notice inviting GEM tender dated 28/1/23. So, sir, the petitioner was graded as L1 in the tender process and in the reverse auction held between the petitioner and the respondent number,
Not respond, he's not responded here, you know,
the petitioner and
L2.
L2, comma, the petitioner was again graded as L1. Yes, sir. However, the work order for supply of textbooks under the tender notice dated 28/1/23 has been allocated by the state respondents to the Assam State Warehousing Corporation, who was not a party to the tender process. Yes, sir. Mr. KP Pathak,
Correspondent numbers 2 and 3. For the textbook cooperation.
just say issue notice, returnable in 3 weeks. Mr. KP Pathak, I accept notice on their response number
2 and 3.
2 and 3 and submits that the distribution of textbooks by the Assam Warehousing Corporation has nearly been completed, in as much as 98.6% of the textbooks have been distributed. Correct?
Yes.
Payment.
And
Who's
payments
for
have,
one? Who is
payments
for-
have also been made.
Huh?
Payments have also been made.
He also submits that payments have been made with respect to the distributed textbooks. Who appears for one? Commissioner Secretary, Government of Assam, School Education.
It is the education department.
Who is the council?
Element.
No, we want, I don't know. It says Department of School Education.
I think my learned.
Who? And what about Warehousing Corporation?
Perhaps
Notice you have to
will
go. Okay, just right. Petitioner takes steps for service of notice upon, huh? Okay, anyway, just right. Petitioner takes steps for service of notice upon the respondents number 4 and 5 by registered post with AD within 2 days. Mr. KP Pathak submits that he will file an affidavit
Extra copies may be served.
within 3 weeks.
3 weeks.
Extra copies of the petition be served to the council for the respondents. List the matter after 3 weeks.
Your lordship, rest of the fund may not be released. Your lordship.
The respondents, the state respondents shall not release any further release any further payment to the respondents number 4 and 5.
Lordship, just one thing. When an interim period is usually made, your lordship, there has to be some pleading to the effect that there is a prima facie case balance of convenience is in his favor. There is no pleading to that effect. in the-
Anyway, next.
So, Lordship Maharaj,
Lordship, for elementary, I can take the notice.
We don't know if it's elementary or what. They said school education. Okay, Miss,
And border.
N. Borderloy, accept notice on behalf of respondent number one. Huh, just-
Obliged.
So basically, if you give your affidavit, it's the
Yes,
end of the
that will be
matter,
it.
that's all.
Obliged.
May it please your lordship.
Item?
Item ten.
Yes,
Lordship, the petitioner here is a license holder of a fair price shop, your lordship,
yes,
under PDS, your lordship.
yes.
Your lordship, you will move on to page 14, your lordship. This is the order, your lordship, suspension order which I have challenged, your lordship.
Yeah,
Your lordship, this order was passed on 31/12/2022. And your lordship, as per Assam Public Distribution of Articles Order 1982, clause 15(2), I cannot be kept in suspension for more than 30 days, your lordship. Today it is 42nd day,
so
your
Mr. Council,
lordship.
you are, so you are aggrieved with this order.
Yes, your lordship.
Is there a provision for appeal?
Yes, your lordship. Yes,
Lordship,
your lordship.
in fact, second appeal is pending, Lordship.
Yes, your
Page
lordship.
21.
Appeal is
page
also
21.
pending. I find
That
that,
appeal may be directed to be disposed of, but similar order they have.
your
annexed.
lordship. But as per clause 15(2), your lordship, the appeal, I had to be heard within 30 days, your lordship. Now it's 42nd day, your lordship. And your lordship.
Will, let it be decided.
Let it be decided first. Similar order they have annexed to this petition also, Lordship. Page 25, Lordship. Operative portion is at page 27, penultimate paragraph, Lordship. Down below.
Okay, right. Heard, Mr.
I will say.
I will say, then counsel for the petitioner. Who submits. That the. Petitioner is a license holder of a fair price shop. Bearing license number BNS/82/89-90/PDS/R/42. In the area under MS Paschim Bhagmara GPSS Limited. The petitioner is aggrieved by the impugned order dated 31/12/22. Issued by the Deputy Commissioner Biswanath. By which the license of the petitioner to run the fair price shops has been suspended under clause 15(1) of the Assam Public Distribution of Articles Order, 1982, full stop. The petitioner's counsel submits that the suspension of a license cannot be cannot be beyond 90 days. And as such, the impugned order should be set aside. Full stop. The petitioner's counsel also submits that the petitioner has submitted an appeal against the order dated 31/12/2022, impugned order dated 31/12/2022, before the Commissioner North Assam Division (Assam). And the same has not been decided till date. Full stop. Mr. R. Talukdar appearing for
Respondent number 1 and 3 to 7.
1 and 3 to 7, and anybody else? And Mr. R. B. Goswami for point number 2. Submit that as the appeal is pending before the appellate authority, a direction may be issued to the appellate authority to dispose of the petitioner's appeal
Lordship.
within a specified time period.
Lordship.
So, correct?
Lordship.
Next paragraph. Considering the submissions made by the councils for the parties, comma. No, not comma, and keeping in view the fact that a suspension of a license should not be beyond 90 days. In terms of clause 15(2), clause 15(2) of the Assam Public Distribution of Articles Order 1982, comma. This court is of the view that the appeal filed by the petitioner before the Commissioner North Assam Division should be disposed of at the earliest. Accordingly, the Commissioner North Assam Division is directed to dispose of the petitioner's appeal dated 12/1/2023 within at the earliest and preferably within a period of
45 days, Lordship. 30 days, Your Lordship.
within a period of 30 days from the date of receipt of a copy of this order. The writ petition is accordingly disposed of.
Lordship. Public.
The petitioner here is a leaseholder of a stone mahal, my lord. And he is praying for
There are five
consideration of this proposal, my lord, for extension.
Settlement of that 6 ends on 12, my lord. Petitioner comes in 2023,
My lord,
seeking extension.
uh,
There are 5.
my lord,
They
FSC clear-
signed these agreements for a period of 5 years.
yes, my lord, but
And the 5 years has expired.
Here also, my lord, without any loss.
my lord, thereafter, my lord, this was forest clearance was given in 2002, my lord, for 20
Mr.
years.
Council,
20 years, my lord,
clearance can be given by anybody. How does it matter?
for 20 years, and thereafter, my lord,
Here, the clearance doesn't give you any right.
my lord, thereafter, he has,
It should be, there should be a new tender process.
respondents call for the mining plan and the.
Maybe.
take
Why
assessment.
should you be given everything? Everyone wants to participate in the mining process. Everybody wants to make money. And in the end, public interest requires that this thing should be auctioned fairly. Why should you be given extension? And that
My
also
lord,
which ended
because-
in the year 2012.
Well, at least his petition.
No case.
His proposal may be considered, my
Why
lord.
should we?
As with-
That is up to them.
Respondent number 2.
No.
Respondent number 2 may be directed
No
to
case.
dispose of his representation at annexure M, my lord.
Filing
Page
a
42, my
doesn't
lord.
make out a case.
Let them pass a speaking order, my lord.
You see, Mr. Council, first of all, when you come to a writ court, you have got to show that some right of yours has been violated and you want redressal of your right, which has been violated. Some enforceable right. You show this court today, right now, what enforceable right of yours has been violated.
My lord, first of all, my lord,
No,
lease
right.
was for 5 years, my lord, and thereafter it was not extended on certain grounds, my lord.
You can go to the division bench.
My lord, at least his representation may be considered, my lord. Whether they reject it or allow it, it's up to them, my lord.
This one is standard
least
of
that,
my lord, because my lord.
but
is
at least
taking
they will
over
pass an
everything.
order
Heard
on
Mr. M. Katania, learned counsel
Annexure
for the
F, my lord.
petitioner, who
that may be
submits
disposed of, my lord.
that the petitioner that the respondent should be directed to approve the proposal submitted by the petitioner on 29/10/2022
Yes, sir.
for extension of his lease term. Till which period?
My lord, it was
Lease
leased
term from which period?
2016, my lord.
From 2016?
But my lord, initially, let me explain, my lord. Initially, the lease was given for 5 years, from 2006 to 2012, my lord, validity period. And thereafter, there is a breathing space of 2 years interval as per the FSC Act. And after that, again, it is given to them.
No.
Similar
Show me
person
those agreements, show me. I think we should haul up those officers for giving you such
My lord, may come
illegal
to
extensions.
Annexure A at page 18, my lord. That is the FSC clearance. And thereafter, my lord, Annexure B is the
Okay, just right, for extension of his lease term. Full stop. Full stop, next. Mr. D. Gogoi, learned counsel for the Forest Department, on the other hand, submits that a perusal of para 5 of the writ petition would clearly go to show that the petitioner had been allowed to operate the stone mahal for a period of 5 years on the basis of the lease agreement dated 7/10/2006. He accordingly submits that there is no question of extending the operation of the Stone Mahal in favor of the petitioner without any basis for the same. Full stop. On considering the submissions made by the counsels for the parties, it is clear that the petitioner has approached this court only for extension of his Stone Mahal. Extension of the lease period of his Stone Mahal, which had ended after 5 years of making the lease agreement dated 7/10/2006. Full stop. It is settled law that in matters of state largesse, LARGESS, state largesse, the state, the state is required to ensure that the public interest is best served by a transparent process of giving auction, wherein wherein different persons can compete for operating a Stone Mahal, thereby ensuring that thereby ensuring that the state is able to get the best price for giving out its resources. First up, the petitioner's prayer in the writ petition is to ensure that only he is able to operate the Stone Mahal and extract the resources by taking out the competition which would be in violation of Article 14 of the Constitution. Full stop. As there is nothing to show that any enforceable legal or fundamental right of the petitioner has been violated in this writ petition, the petitioner cannot be said to be an aggrieved person. Full stop. As such, this court does not find any reason to exercise its discretion in this case. The writ petition is accordingly dismissed.
My lord, my lord, one small submission, My lord, at annexure J, there is a passed in 23/7/21, there is a proposal for his extension, man.
That if they want to extend, they will extend.
So,
This
my
court
lord,
is not going to give any
My
handle to you to do something
at
which
least
is
my
legal.
representation may be considered, man.
Huh?
My representation may be considered in view of that communication by the
No. That,
principal
there's no bar on the government to do. Why should we give?
page 35.
We are
my
not
lord.
going to give you any handle.
Page 35, man.
We are not going to give you any handle, Mr. Counsel.
But there's a communication for extension because he could not recover his loss. In view of that,
I am holding a judgment.
representation may be considered. And in view of this communication of 23/7/21, where extension was supposed to be granted, my lord. Page 35.
Right. In the case of Meerut Development Authority versus Association of Management Studies, reported in 2009 6 SCC 171. The apex court has held that even in contractual matters, comma, the state or other authorities are bound to act within legal limits. And actions are to be free from arbitrariness and favoritism. The state is bound to take into account all relevant considerations, eschewing all irrelevant considerations in awarding any state largesse to individuals. Full stop. Keeping in view the judgment of the apex court, this court does not find any ground to allow this writ petition, especially when his term was for settlement of the Stone Mahal ended in the year 2012. So, ended 5 years after the execution of the agreement made in 2006.
Please, Your Lordship. There, my lord, petitioner is belongs to every candidate, my lord. And my lord, he applied.
Have you, now, has the committee declared you to be SC?
Yes, my lord,
Declared.
declared, my lord.
And you have been given the third installment?
Third installment given, my lord, then they approached that national commission, that is page number.
So
one.
you have been given the third installment, you have
Yes.
been declared SC.
Yes, my lord,
Only thing is that the payment was made late.
yes, my lord.
And because of the late payment, now you did not make the money you were supposed to make
Yes,
earlier.
my lord. And my lord, they approached that national, that page 140.
Damages, file suit for damages.
But my lord, that comes under atrocity act, my lord, that's
Ah.
why- atrocity act, my lord, that is under,
But where is the atrocity, madam? They are verifying.
my lord, kindly see 148, my lord.
Okay, we'll issue notice,
correct,
we'll issue notice, that's all. Okay, heard Mr. A. Gayan, learned counsel for the petitioner who submits that due to the delay by the state respondents in releasing the third installment of the loan,
Yes, the not
Oh,
loan, that
not loan.
scholarship, scholarship.
third installment of the scholarship, and in view of the delay, no, and in view of the respondents questioning whether the petitioner was SC, scheduled caste, belong to the scheduled caste category, comma. The petitioner has suffered immensely, including late payment of, has suffered immensely, both financially and mentally. Full stop. Which is full stop, accordingly. The persons who are responsible for the same have violated the provisions of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act, 1989. Issue notice returnable in 4 weeks. Yes, who accepts notice?
Lordship, I am appearing for respondent number 1, 4 and 5.
R. Talukdar accepts notice on behalf of respondents number 1,
4 and 5.
4 and 5. What about 2 and 3?
WPT department standing
who?
counsel is there. Usually Mr. Ardhar appears.
It is right, Mr. Ardhar accept notice on their response number 2 and 3. List the matter after 4 weeks.
Must not be.
Apply.
May please, Your Lord.
Yes.
My lord, I am agreed by the action of the respondent number 3, my lord, in issuing a notice to vacate my Pata land, my lord. Respondent number.
Yeah, just a minute. Atalan.
Yes, my lord.
And what is this miss case? There is one miss case.
My lord,
What is
that
it?
is, my lord, at page 18, my lord, an application was made by respondent number 4, saying that there was a compromise to be made by the circle.
Okay, just 1 minute, huh? I'll
Yes,
just.
my lord.
Okay, so basically 4 wants to buy your land.
Yes, my lord. So as he says, as we are
Okay,
saying
okay.
here, so
So where is, so we'll state that miss case.
miscase as well as, my lord, the notice that is at page number 22, my lord, whereby I was directed to hand over a portion of the land, my lord, that is
Okay,
also to be
okay,
stated
right. Heard, Mr.
here, some.
So and so, learned counsel for the petitioners who submits that the respondent number 4 has been trying to buy the land of the petitioners covered by measuring 2 bighas, 3 kata,
No, my
3.
lord. Land she wants to purchase.
No, no,
for-
your land. Yeah.
Total, total land.
Two big.
Just say that, heard Mr. Spencer, counsel for the petitioners who submits that the respondent number 4 is trying to buy a portion of the petitioner's lands, which is covered by DAG number 387 of KP Patta number 237 at village Moi Ramara and Gilajori Moza in Barpeta district. Full stop. The petitioner's counsel submits that the petitioners are in possession and occupation of land measuring 2 bighas, 3 kathas and 13 lechas, covered by DAG number 387 of KP Patta 237. Full stop. The respondent number 4, who is the owner of land covered by DAG number 825 and Patta number 358, is adjacent to the land, to the petitioner's land. Full stop. The petitioner, no, the next paragraph, the respondent number 4 had approached the petitioners for transferring a portion of their lands by selling it to the respondent number 4. Full stop. However, as the petitioners were not willing to sell their land, the respondent number 4 approached the circle officer seeking his intervention. Full stop. Consequently, the circle officer has registered miscellaneous case number 116/2022-2023 and issued notice dated 27/3/2023 to the petitioners. Full stop. Issue notice returnable in 4 weeks. Ms. N. Bordoloy accept notice on behalf of
Respondent number 1.
respondent number 1. What about 2?
I can look at for respondent number 2 and 3.
Mr. R. Talukdar for respondents number 2 and 3. Petitioner takes steps for service of notice upon the respondent number 4. This is the matter after 4 weeks. In the interim, the proceedings that in the interim, the notice dated
27/3.
Huh?
27/3.
27/3, so 27/3/2023 shall remain suspended, shall be kept suspended, and
Also
the proceedings in miscellaneous case number 116/2022-2023 shall also be kept suspended
All right, my lord.
till the next day.
Lordship, the page initiations are little, not.
You're paging it. Paging it.
Yes, my lord. If there is a mistake, I will correct it. In paging. Okay, Mr. Tarun, there is not here.
Item?
Item number 7, my lord,
can you
along with
take up-
item number 21, 22, 23, 24, my lord. Kindly the matter may pass over for a time being, my lord. He's on legs, my lord.
Who?
SK Talukdar, my lord.
Okay. Yes, next,
On legs, my lord.
next.
May it please, your lord.
Jeff,
My lord, the petitioner association is a society, my lord. It has 78 fish sellers. We sell fish in the market.
yes,
The Mongolway Municipal Board allotted us fish seeds and we pay taxes for that. Now in 2018, there was a move. They constructed a new market, 84 fish sellers to come in there. We unsuccessfully participated, that's all. 4 of us got through also. Now, since they wanted to evict us and put there in, we approached this honorable court. And recording is
evict you from the old market.
from the old market and recording is 10 of the board. An order was passed at page 34, that's 2nd of April 2018, page 34. The last line would suffice, my lord.
Yes, yes.
It says that the apprehension expressed by the petitioners that they would be evicted is entirely misplaced because by resolution adopted and.
Status quo was resolved to be maintained.
Yes, so we both continued. Now, some other persons challenged the allotment of the new market on the count that this was something fishy was there. Initially, there was a stay order, status quo order.
So to challenge them in what, in which writ petition?
That was, my lord, let's get the case numbers. That was in 2432 of 17,
2432 or 17.
2432 of 17.
So is that still
It's pending, it's pending.
pending?
Initially, there was a status quo order. Then the board, the municipal board filed an interlocutory application for vacation of the status quo order. And there is the status quo order was vacated, giving that the 4 fish seats or stalls on the front side for the 4 petitioners. The rest you go ahead.
In the new market or in the
In
old
the new
market?
market, in the new market.
So that has
So-
nothing to do with you.
Nothing to do with us. So peacefully, both were there. Now, recently, on 22nd of March, the chairman of the board writes to one of the petitioners, who's also a member of the society, that what is the status of that old case? The board got the status quo order vacated, and now they write, what is the status of that old case?
Which case? The 2432.
2432.
Yeah.
The very case which the board got the status quo order vacated. Now in 2023, they write to that man, what is the status of that case? He is a member of the society also. Now, we immediately went through, the secretary said, sir, what is
So how does that, how does that, what is the relevance of that?
that relevance is, once everything is running on peacefully, if they bring in fresh LOTs, that's what we're given to understand to us.
Mr. Council,
we made a statement.
that is with regard to the new fish
No, no,
market.
we
It has
have made a-
nothing to do
We
with
have
you.
made a categorical statement, Milord.
Huh?
We have made a categorical statement.
But this is where you may make any categorical
Madam-
statement, but then
On,
where is your, how does it,
with that observation, if Lordship closes the writ petition.
No,
I'll
no,
be
why
open.
should we close it? Where? Why should we,
Why not,
why should we go into uncharted territory when there's nothing to show that any right of yours has been violated?
My lord, page 11, paragraph 12, we thought so, therefore put it on
No,
record.
no, your thinking so will not do, na.
We had gone there.
Your
had-
apprehension, your
No, we
speculation.
had word with them. We had a word with them.
Where is your letter to them?
But we had a
Where-
word with,
Where is your letter to them? Where is your representation to them?
there's hardly a time to write, my lord. These things
Then
go
you,
on.
if you have the time to file a writ petition, you have a time to file. You cannot come directly to the writ court just like that on your apprehension.
It's not apprehension, my lord. May I read out what we stated actually, at least what we.
No, 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 you show me that if you have an apprehension that your old market is going to be, some seats are going to be given to some person,
Even that
also, or that
observation-
you're going to be evicted.
Even that
Where
observation.
is,
helps, my lord.
where is your representation made to them? It's not here. You go to them, you file a representation to them with whatever apprehensions you have. You go to the authorities first. Don't come directly to this court. That also when no right has been violated. I can understand
The
if some
status
right
quo-
has
the
been
status
violated.
quo order was there. In the earlier case, they got
No
it vacated.
case,
Now
no
they
case.
come up there, my lord.
No case. Mr. You go, you find a representation there.
That observation would help. That observation. would
No,
help.
no observation. I am dismissing your case.
But
There's no
Lordship
representation.
may not dismiss this case.
I am dismissing it. What you can do is if you want, you can withdraw this case with liberty to approach the authority with your grievance. That's all.
Could that be on the reopening?
Huh?
Because I need the consent to, and the instructions to withdraw. my lord. Could that be on the reopening?
No, no, no. I'm dismissing it now. I cannot wait. Just
Then the Lordship would pass
heard
it.
this, sir.
But may I
Yes,
rephrase my
Bani.
submission, Miller?
Huh.
Instead of withdrawing, Miller, withdraw would be on me as a lawyer. Lordship may close it, but I pray for the liberty. Lordship may close it on that. Withdraw after all. it
No,
affects
no,
the
I'm
lawyer.
not going to, I'm going to dismiss it there's no question of closing it. I don't see any right of yours being violated out here.
Then I seek the liberty to approach with to canvass this grievance.
Yes.
But Lordship may observe one thing, that the earlier writ petition, the status quo order was vacated by them and now they issued a notice. Backhand.
Where? There's nothing here against you. It's only your applications which you have put by way of an averment in your writ petition. There is no representation also submitted
But the
by you
sub-
to the
But the
authority.
substance of that notice can be wrong. The very authorities, the change of guard. the very
Nothing,
authorities
nothing is there. Nothing. Heard, Mr. So what is your decision?
We would approach them.
Yeah.
We would approach them,
Okay, Mr. S. Banik,
black and white.
learned counsel for the petitioner, prays that he may be allowed to withdraw the writ petition with liberty to approach to whom?
The chairman of the municipal board,
Approach the
Mongolian Municipal Board.
chairman of the Mongoldoy Municipal Board with regard to their grievance. What's up? Mr. R. Talukdar appears for
Respondent number 1 and 2.
response number 1, 2. The prayer of Mr. S. Banik is allowed. The writ petition is dismissed as withdrawn with liberty as paid for.
Please, your lordship, then this petition has been preferred by this petitioner in connection to the notice inviting tender from the GMC for settling of the lease market.
Just a minute, petitioner, you took part in the NIT.
Yes, my lord.
NIT for settlement of a market.
Yes, my lord.
For which period?
For 23 to 24. That-
23 to 24. That means from April.
Yes, 1st of April till 31st of March.
Then,
20. So
then-
now what has happened is that after participating in the tender process, I was in the number one position.
number
Serial
one.
number one, it is there in the comparative.
So highest price.
No, I'm not the highest bidder, I am the valid bidder. Here, the basic thing is that there has to be some requirements that has to be fulfilled. And in that process, I have fulfilled all the requirements, including depositing the earnest money deposit, which is under the SC category. I belong to the SC category, so 5% it comes on the offer value. So I had offered whatever amount, I had also deposited the earnest.
Okay, so you're the valid bidder
Yes,
then.
yes, my lord.
And
That is
then-
in page number 20, Annexure B. That is the comparative statement. Kindly peruse to page number 20. I'm in serial number 1. That is Mercer's Ganapati Enterprise, which is actually represented from my side. I'm Dharmakanda Das. Now, what has happened is that after
What
this,
about the number 2?
the number 2, they have not fulfilled the criteria. They are below the, they have not satisfied the exact criteria which are required for getting the tender. And number 3 is also the same. For second one, we have got apprehension that
So you have, so now what is your problem?
my lord, after this particular tender was opened on 26/3, this tender was called on 2/3/2023, and then it was opened on 26/3, which was duly in front of the GMC officials. Now, after opening of this tender, I am being the valid bidder. I should be called and I should be given that this one, the lease contract for the coming year.
Correct. So what has happened?
Now, what has happened is that when I have gone to the office to get my confirmation, they have not given me any sort of communication. They have not made any communication. They have not corresponded with me. In fact, when I have asked them to show what is the result, they have said it that we are in a process. And now I have come to know that they are going to extend that particular previous year's party, who is the serial number 2, Potik Das. He is now, we have made private respondent.
Respondent number?
Respondent number 7, that is Potik Das. He was actually holding the previous lease contract agreement. And now again, this person,
He's going to be extended for how long?
one month, they are going to extend to 1 month, and in the period, they are going to issue, they are in the process of issuing a retender, which is totally in violation of my right, since I have duly fulfilled all the criteria and I am the valid bidder. So that is my apprehension, and I have come with my right. And for that, I have also approached their RTI department, and I have made an application to their department on 6/4 with all the seeking all the requested information. Now, our prayer is that to make sure that my validity has been considered and my
Yes,
credential. So we are praying for staying the operation at this moment for reissuing any tender.
Yes.
20 lots.
20.
Yes,
Yes,
this is the comparative statement lordship.
yes,
Lordship will see 3 bidders were there.
yes.
Last column lordship, for second one rejected, third one rejected. So he is the only bidder remain lordship.
Yes.
Lordship, when there is only one bidder lordship, in that situation, it is necessary for the authority lordship to issue a fresh tender lordship.
Where does it say that?
That is the CBC guideline. Lordship.
No, that guideline is for different issues, not for this market business.
Absolutely. Well,
That is CVG guideline.
it is totally important.
Authority has already decided lordship to not to go with this tender
Huh?
lordship. Authority have already decided not to go with this tender lordship.
Not to go.
Yes, because of this reason only. And yes, he is correct, lordship. Authority is contemplating to issue a fresh tender.
My lord. When I
It is
fulfill
for that
everything,
reason only, lordship, 1 month's extension has been granted for 1 month only. Lordship.
the authorities are doing it, my lord, only to accommodate the private respondent number 7. He was not at all.
Your tendered amount was how much?
I had offered for 1,25,15,000,
It's
of
first
which I have
first-
already deposited that 5%. That is,
And they have?
they have offered this Potik Das 1,28,50,700.
Okay, right. Heard, Mr.
WR Mehdi.
W.R. Medi, learned counsel for the petitioner, who submits that the petitioner and two others had taken part in the tender notice dated 2/3/2023 for settlement of the Beltola bi-weekly market for the year 2023-2024, with effect from 1/4/2023 to 31/3/2024. Full stop. The petitioner had tendered the bid amount of rupees 1,25,15,000, while the respondent number 7 had tendered the amount of rupees 1,28,50,700. Page 28 there, huh? The third tenderer had submitted a bid amount of 1,51,00,365. As the other two tenderers bids,
In case of second one, Lordship, his earnest money deposit was 35 rupees less. Actually, he rounded up the figure and he's deposited the earnest money of less 35 rupees less. Lordship. And for that reason only his tender was rejected. And in the third case, Lordship will notice his bid.
so
was-
that is a curable defect. It could have been cured.
Yes, Lordship, that is there.
Then,
If Lordship allows us, then Lordship.
no, why should I allow? That is,
Lordship.
no one has come. Why should that is.
No, but what I'm submitting, Lordship, that process is not yet completed. Authority and whatever authority is considering.
Anyway, right. As the other two bidders had not been found, as the bids of the other two bidders had not been found valid, the tender was to have been, the tender submitted by the petitioner was to have been accepted. So the petitioner's case is that the state respondents have taken a decision to extend the settlement of the Beltola bi-weekly market by 1 month to the respondent number 7, who is the present settlement holder of the market. Stop. Full stop. Also, the state respondents are planning to issue a fresh NIT in respect of the Beltola bi-weekly market. Full stop. Issue notice returnable in 3 weeks,
2 weeks, Lord.
2 weeks. Mr. P. Nayak accept notice on behalf of respondents number
But I'm appearing for GMC authority. 1, 2, 3, 4, 5 lots.
1 to 5.
Yes, sir.
Madam, is
6
there
also, 6 also. Lord.
1 to 6? Petitioner takes steps for service of notice upon the respondent number 7. By registered post with AD within 2 days. In addition to the above, the petition shall also serve notice upon the respondent number 7 by the through dusty service. List the matter on when? Third date. Today is 14. 13. 28. List the matter on 27.
Yes.
List the matter on 27. Full stop. Till the next date, comma. No fresh NIT should be issued by the respondents in respect of the Beltola bi-weekly market, and no extension of the
Lord, nobody will be there, Lord. Earlier settlement is already over.
and no extension of the settlement of the market in favor of the respondent number 7 should be made for the month of April
No, no,
20
but lots of, with some arrangement will have to made by us, Lordship.
You do it,
It's a fast market, Lordship, and Lordship will see the amount, Lordship.
then let the petitioner do it.
Lordship, it has already been issued, Lordship, let
Huh?
it complete. Today is 14, 12.
Correct.
Lordship.
If so,
So,
so if
we
that,
are-
that,
we
if
are-
that settlement has been,
Lordship,
it's
we are-
over, if it is over, then let him do it.
That is my.
No,
Uh,
if that is there, Lordship, if at all. tender
No,
is
no settlement, no extension of the settlement should be made in favor of the respondent number 7 for the month of April. Full stop. However, if required, however, the petitioner, the respondents may allow the petitioner to,
No, I'm
to,
objecting that, Lordship.
Huh?
He has no right, till now, no right has active in his favor.
correct, no, right, so I said
Lordship will give us-
I said may, I'm not saying should.
Lordship will say then the authority will manage it of their own lords. Let the authority manage lordship. If your
They
lordship
will
is-
allow, but then you see, that-
Let me.
however,
Till now,
however,
lordship, no
the
right.
petitioner may allow the petitioner, however, the authorities may allow the petitioner
My lord.
to run the market for the month of April.
My lord.
May allow it, may allow.
Lordship will give us that option also, Lordship. Lordship has the total one option only. Lordship will give us the option also to be managed by the authority in themselves, Lord.
My lord,
I'm just praying for the option, Lordship.
How will you?
No, your
But
lordship has given an opinion, observation, Lordship, in favor of a person in whose favor no right has accrued till now, Lordship.
Lord,
It's
it's the
a-
valid bidder. I am ready to accept it and I'm going
Yes,
to also.
no,
accept
you too will accept,
Yes.
naturally. Why won't you accept
Yes.
that? That's why you have come to this court
Yes.
anyway.
He has.
I want to
he
run
has
the
challenged
market.
The process,
Let us give me the chance also with all my ability.
No,
If it is
it's
given,
not that. That's right. However, I said, however,
However, the authorities may allow the petitioner to run the market for the month of April.
may allow the market or may allow the petitioner the market for the month of April or run it themselves. Or run it themselves. Comma, but not through the respondent number 7.
man, oblige, man.
May I please go now? This matter, your lordship, leads to is a land acquisition matter. What has happened, your lordship, a notice was issued for land acquisition of the land of the petitioner. What has happened? We have objected to the same. There was a.
You have objected to the land acquisition.
Yes, for 2 reasons, your lordship. Basically, what has happened, we are not objecting to the land construction of the road and the bridge. It has to be constructed. We are not against that. Also, you take the land which is required. Now, what they have done, they have only taken the land on the western side of the road, which is my land, and have not taken any land from the eastern side. So they have made it like this. So that we are objecting. We said that I have a pond, and from that particular pond, I am fishing, and my livelihood, I am running the family. That will be affected. If you take it from the, normally what is done, both sides is, normally when you construct a road, both sides is taken. So that I have made the objections. They have also called me for hearing. Then finally, the ADC have also asked the PWD to give a report on that. When during the pendency of that, now they are starting to start the construction. That is basically the case. My case is that you take the part, shift both sides equally and take the land. That will not affect me, but you are just running the whole land. You are just taking the acquisition only on only my land and leaving aside the other side on that part only. Rest they have taken. That part they are doing that. That is basically my case. And in fact, they have not thereafter communicated as per law. They should have communicated that after giving the notice, taking over the land. That
Okay,
also
so
they-
what do you want? Do you want the representation to be decided?
So my representation was actually taken care of. In fact, your lordship will see at the last
Okay, so
page,
you
page
want, okay,
32,
uh,
page 32, your last page. This was the detailed report was
okay,
sought,
so we'll issue notice, that's all.
the detailed report sought for by the
Yeah,
additional.
we'll
deputy.
issue notice, that's all. What else can be done?
At least your lordship, not to take my pond for the time being. Till, since it is 8 months.
Let us hear what they want to say.
No, since I'm saying 8 months from the date of the notice has come. Now they are trying to take over the land. It is only parties.
Rakesh.
May I, your lordship? May I submit your lordship?
Till the next date, your lordship, at least.
May I submit your lordship?
Yes, yes.
Since the requiring authority is the PWD department,
PW department report is also sought for by the ABC. Your Lordship. The PW department needs to be a party in this.
Not a party.
My lord, just one paragraph, page 181, my lord.
Lordship, if your lordship remembers, lordship has taken up a similar matter some days back.
Yes, yes, yes.
Same issue, lordship.
What did we do with that matter?
Lordship had dismissed that.
I think, yeah.
Here, they cite the division bench judgment where the division bench had said that they will be heard. Now they have come up with a plea that they were not heard. In fact, I have got the minus of the hearing. They have been heard, which they are suppressing now.
No, my lord, just, I am the petitioner, my lord, let me, then my learned friend. Yes, because I have
But
something,
please come with clean
my lord,
hands.
we have been continuing this business for years, for generations, my lord. Now, our question of livelihood is also there. My lord, lordship will see in the writ appeal, we were allowed to continue our business at page 81. And an opportunity was given. for
Look,
yes,
I'm having slight problem.
lost, all right.
Okay, and I've got to go to the hospital now.
My lord, yes.
I'm on painkillers
Yes,
right
yes.
now.
Yes,
So that,
yes. My lord, may I pray just my status could be maintained at this. Only that must, my lord. My lord, I can understand lordship is that.
we'll take it up after 2. I'll go to the hospital and come.
Let it be
My lord,
after the-
your lordship is not well, my lord, not required, my lord.
After 2.
Not required, my lord.
Lordship, let it be after the vacation.
After the vacation, and
Lordship-
if possible, my lord, status code.
That's right, this is the matter on 19th.
Lordship.
Then the other items, I'll take it up at 2.
The
My lord,
next case-
29 also same, my lord, then let it come on
Two.
19th.
I'll take it at 19. At other items at 2.
Into the cooperative society matters, my lord.
21.
21. The facts, my lord, literally, my lord, has gone through. I'll only, my lord, address on your lordship with regard to that constitutional.
Basically, all these cases, they have been, the 6 years period has gone.
5 years period gone,
5 year period. gone.
period gone. In 1 or 2 cases, 6 years is not complete. And in all these cases, right from the beginning, they were asking for holding the meeting either on COVID or without extension. This was not being given.
No, okay. No, so that being the case, anyway, the issue is basically one is whether you'd be debarred from participating in
That's a
the
different issue. Yes.
the election. That is one. And the basic thing is when the constitution provides that it will be 5 years and the state government has made a law which provides that it will be 5 years in tandem with the constitution. Whether,
I am not sure why this order was not brought to your lordship's notice. I
Okay.
also did not know about it.
okay,
This was brought in by the 97th amendment. This was assailed before the, my lord, the High Court of Gujarat.
which para?
My lord will have para 2, my lord.
Para 2, yes.
Para 2. These appeals raise an important question as to the virus of the Constitution 97th Amendment Act 2011, in which inter alia introduced Part 9B of the chapter heading Cooperative Societies. The Constitution 97 Amendment was passed by requisite majority of the Lok Sabha on so and so and the Rajya Sabha on so and so. The presidential assent to the said amendment was followed on so and so, and the said amendment was published in the official gazette on so and so, coming into force with effect from 15/2/2022. The important question raised in this petition, decided by a division bench of the Gujarat High Court by the impugned judgment dated 22/4/2013, is whether Part 9B is non-est for want of rectification by half of the states under the proviso to Article 368(2). The impugned judgment of the High Court has declared that the said constitutional amendments inserting Part 9B is ultra vires the Constitution of India for want of requisite ratification from the under Article 368(2) proviso, which however will not impact the amendments that have been made in Article 19(1)(c) and in inserting 43B in the Constitution of India. Now, this was carried upon appeal to the Supreme Court. The Supreme Court upheld this part, madam. It only made 97 Part B
No,
applicable.
no, what is this 97 Amendment Act?
That whole Z 243Z onwards is brought in by the 97 Amendment.
Okay,
That was interfered with by the Gujarat High Court. Went upon appeal, madam, before the Supreme Court. That, my lord, would find at page, paragraph 70.
the impugned judgment of the High Court has declared that the said constitutional amendment is ultra vires the Constitution for want of so those are not
Applicable.
those the 347, 343,
243, whole thing is
the
not
whole
applicable.
thing is not applicable.
My lord will only come to para 81, my lord. I think at last, towards the last, I put a mark, madam.
Para 81,
81. That's the conclusion.
para 81.
I think I put a flag mark there. It's not there.
So then why is it still in the
I
statute?
don't know, my lord. I
Huh?
don't know. This I got it, my lord. The para 81, the judgment of the High Court is upheld except to the extent that it strikes down entirety of so and so Constitution of India. As held by us above, it is declared that Part 9B of the Constitution is operative only insofar as it concerns multi-state cooperative societies, both within the various states and in the Union Territories of India. So what the Supreme Court did was, my lord, the Gujarat High Court had set aside everything, even, my lord, for societies and multi-level state societies. Supreme Court retained that for the multi-state cooperative societies. For the other cooperative societies, it was said that it is not applicable because it comes under list 2.
What do you mean by multi-state?
My lord, multi-state means, my lord, wherein the operation, it's defined there, my lord, wherein means a society with objects not confined to one state and registered or deemed to be registered under any law for the time being in force relating to such cooperative. Wherein, my lord, a cooperative society acts beyond the state, my lord, to another state or more than one, then it's called a multi-level state cooperative society. And for that, this provision of 243ZH onwards was made applicable. Others,
Not for,
not for me, but
not for those cooperative societies
Switched
within
up.
one state.
one state, because, my lord, that day I made a mistake, my lord. It's actually list 2 entry 32.
List 2.
List 2 entry 32 pertains to, my lord, the cooperative societies of the state. And it says the legislative competence therein is with the state government and the central cannot legislate on that. That's basically, my lord. the-
Yes. But on
If
that
that
point,
goes.
no, that is only one part of the
No,
issue.
Fine, madam.
Now we'll have to again interpret then, we'll have to interpret that
I'll come to
138.
that also, madam. I'll come to that. Let him answer.
My Linux will submit, I will let him.
No, on that point, are you in agreement on this point?
No, I have to go through it. If it is, in fact, struck down, then that will not apply. That is.
That is what he's saying.
Yes.
So he's saying that in terms of the judgment passed by the apex court on 20th July 2021,
21.
just that nearly 2 years back.
Right.
And that 243
ZH.
articles 243 ZH and all those, they would not be applicable to the case in hand. And as such, the law made by the state with respect to 130, section 138 would continue to hold the field.
Lordship.
Now, the only thing then would have to be decided is the interpretation of 138. That's all.
Let him complete.
So, no.
Yes.
So we have to be, you see, let us go one step at a time. There's no point him arguing for 30 minutes and then you getting stuck in the first step. You know, there's no point. If he argues and then we hear him and then you say that I have to clarify this, I've got to read the judgment. There's no point. We are wasting everyone's time. So you what do you want to do? Do you want to read the judgment first and then go on to the next step? Or you say that you accept this without reading it? I'll leave it up to you, completely up to you. To satisfy your curiosity, I think it's prudent to maybe go through the judgment.
I'll go through it.
You go through the judgment, and in that case, Article 254 will not be applicable.
243 will not be.
254 will not be applicable.
No repugnancy there.
So if 254 is not applicable, then we go straight to
130.
the interpretation of 138, whether it will be for 1 year or it can be for till kingdom come. Because according to his interpretation, there's no time limit then.
Because they are acting, well, they are giving it in the 7th year also.
No, that doesn't mean that it can a law be there till the kingdom come? I don't know.
No, my lord, because there were orders of this honorable court wherein my friend also appeared, and that led to those things. If that be so, that means, my lord, it's permissible.
I don't know.
You can have a pick and choose. my lord.
That is your submission.
Lordship.
On
We
that
will
note,
have
I have
to-
an submission, madam.
So let him clarify this issue. Because
And,
I see, I don't want to hear you for 30 minutes
Lordship,
and he getting stuck on the first issue.
that's
itself.
true, my lord, that's true.
The Supreme Court is very clear, madam. I cannot say anything, madam.
No, I want you to maybe go through this and find out if there's anything
Yes.
in between, which might not be compatible with his interpretation of the judgment. I don't know. You go through.
Madam, even if what I'm submitting, even if keeping aside, madam, this constitutional mandate, madam, if I rely on the statutory prescription, even then, my lord,
No, but statutory prescription,
Yes.
okay.
even then, my lord, the exemption beyond 1 year in terms of 138.
That is
It's
going
not
to be,
permissible.
that is going to be a
Yes.
submission, no doubt.
Yes, ma'am.
But at the end, but let
Well,
us, let
what-
us, there,
what
let
I'm
us
trying to say-
one step at a time.
Yes. So what,
So this first step, let us be clear about this first step.
Yes.
I want to be clear about this first step as to whether, if you say you don't want to read, it's okay, we can carry on. But if you say you want to read, then we have to give you time to go through it. That's all. It completely depends upon you. What do you want? What do you want? Do you want to read this and be clear?
my lord, what I'm trying to say, that I have my submission in respect of the statutory prescription also. Yes,
Correct,
irrespective of, my lord, the constitutional
Agreed,
mandate,
agreed.
because eventually your lordship will not interpret a statutory, my lord, provision redundant to the other provisions, my lord. Because
Correct.
this will also, my lord, hold the field. The statutory prescription will also hold the field, irrespective of the constitutional mandate. So in that context, lordship may take up the matter.
And
I don't
my lord,
have
we'll
it.
have to also explain one thing
Yes.
as to how today he is coming up with that
No, no.
argument when in the
No,
other
I'll go
cases,
through it. No, I'll
before
go
the
through it.
honorable single judge, these points were never raised.
No, I'll
And
go through it.
thereafter
Lordship-
permitted to take 7 years, copies were marked.
Lordship will give me, I'll go through it, no problem, man.
Huh?
Lordship will give me time, I'll go through it, my lord, no problem.
No, it depends
It's
upon
not
you.
yet,
I'm
problem.
leaving it up to you.
Yes, yes.
Otherwise, I'm ready.
Yes.
It depends upon you. You see, I don't want to waste time. Your time, my time, everyone's time. If you want, because the issue is simple.
Well-
Number one thing is whether it is repugnant
Yes.
to 243 ZH. If he says it is not in view of this judgment. Now you read through this judgment and
Yes.
say if it is not.
After vacation, my lordship will.
Then-
take up the bill.
The second issue is, of course, straight away, then the only issue that remains is interpretation of 138, that's all. And you have to explain why you have given relaxation after 7 years.
Right.
If you say that it cannot be given beyond 6 years,
Yes.
that's all. I
Yes,
mean,
that's-
it's a very limited,
Limited.
a limited playing field.
Correct.
Okay, right. Mr. Yukena, Learned Senior Counsel for the petitioner submits that in terms of the judgment of the Apex Court in Union of India versus Rajendra N. Shah and another, reported in 2021 SCC online SC 474, wherein the judgment of the Gujarat High Court, Division Bench of the Gujarat High Court has been upheld declaring the Constitution 97 Amendment Act inserted in part 9B, capital B, Roman 9, as ultra virus, the Constitution. For want of the requisite ratification under Article 368(2). Proviso. Renders the said amendments, renders Article 343 ZH and
To my lord, Z,
343 ZA.
243 ZH to 243 ZQ. And
Article,
ZT
Article
My lord, let's say-
243 ZA,
to ZQ.
243 ZJ,
Lordship,
ZA and ZJ, I think.
ZH, my lord. ZH onwards, it starts 9B.
Okay, ZH onward as,
My lord will put it like this, that it is only applicable to multi-state cooperative. society.
what have I said?
Renders Article 343H and.
Onwards.
343
Onward as ultra virus and would only be applicable in respect of
Multi-state cooperative society.
multi-state cooperative societies.
Lordship.
Full stop. Mr. S.K. Talukdar submits that he needs time to go through the judgment of the apex court. Accordingly, list this matter on
My lord. Having it on reopening.
Huh?
Well, my lord is keeping it on reopening.
here can have it any day.
My lord is coming back on.
I'm coming only on the first week. I'll be
Okay.
coming back on the first.
My lord would do one thing, my lord. My lord will hear the matter, no problem, my lord will.
No,
But
I
in
don't
the
need to hear. It can be
No, because
heard
my lord
by.
has already gone into the issue. My lord has already gone into the issue. My lord will keep it part, let it be, my lord, on the first. In the meantime, my lord, let there be no election by the officer. That much only. Otherwise, our coffers will be finished. That's what we feel. My lord will have it on the first week, because my lord has already gone through it. It's only the judgment practically, my lord, will after hearing it. I have also literally completed. Only
There's,
on
there's,
one-
there's
one
nothing
thirty-
much, there's nothing much to decide now.
Nothing much to decide. That's what I'm saying. 1:30, I'll make my submissions for 10 minutes, then my friend can. my lord.
Yeah, 10 minutes will turn to,
No, my lord. No, never. My lord.
yeah, because if you remember from the start, we bring out 1, 2 points, then it expands a little bit.
No, my lord, my lord gave me that opportunity, so I could do that research. I got this. I was surprised, my lord. The state knows it. Maybe my friend does not know it, but the state knows about this. Because the states they were also, my lord, in that point of time being communicated with this. I don't know why the state has not placed it before my friend.
Because they knew it, they made 130A. Probably.
No, 130A came before that.
138 came before that.
Came before.
Came before that.
Came before that.
But same year.
It's in, my lord, 150A came to effect or no, my lord, earlier, 20. The thing was on, it was on 21 June. And this judgment is of June.
Okay.
And it has been made effective from
So you're lucky.
lucky 20.
Yes, sir, you're lucky.
Lucky. 20.
You're very lucky.
No, they have given it effect from 25/3/2020. This amendment.
No, whatever it is, you're lucky because otherwise no one would have known anything.
Lordship.
And then we would have decided this
would have been-
under 254.
254, my lord.
Huh.
Because I was worried, my lord, why? But that's why I was trying to say, my legislative intent, how they, but constitution amendment, I thought it can be. Because it's not a parliament made law, but a statute to that effect.
Out here, in fact, it is not a clash between parliament made law and
No.
and It's between the constitution and the
It's a-
state made law.
And the Supreme Court, my lord, while saying not ratified, even went to examine in that judgment, my lord, whether the parliament has a power to, my lord, get into a field which is, my lord, the legislative field of the state government. That aspect, I learned something from this, my lord. It was good for me. My lord will have it on paper, but in the meantime, my lord, let there be no elections, my lord.
Yes, don't have the elections during the time being. Otherwise, how can we decide? That
Decide
become infructuous.
Election, my lord.
This matter will become infructuous otherwise.
It
My
will
lord-
take 90 days, my lord, to hold
Huh?
the election.
No. A
90
night,
days.
the election takes, my lord, if they want it, the 90 days is for them to enjoy.
Okay, right. But you don't have to have it before me, it says,
My
it's
lord,
a small issue.
I just heard it, my lord. My lord will keep it.
I have not heard, I've only heard the periphery.
My lord, things have been unearthed before your lordship now, because of the endeavors, time spent by my lord. My lord will have it on first. Anyway, my lord. My lord has not made up. his mind.
First, you'll be the only person here. First, I'm arriving only.
No, my
it's a
lord. Second
holiday.
or third,
First
whenever,
is a holiday.
whenever it's my lord convenient.
Okay, right, then continue, huh? This is the matter on. Fourth,
Lordship,
Thursday,
Thursday, my lord.
this is the matter on fourth. In the interim, the one-man commission should not conduct any elections till the next day.
My lord, that will do.
That is in all the cases,
All the cases.
all the
will come-
cases. Huh? You
And
just,
he'll give the
you
list.
just
It will
tag them
come
all,
with tag matters.
tag them in one order. Item 7,
7,
22, 23, 24,
21,
20.
22, 23, 24.
7, 21, 22, 23, 24.
Yes.
Much obliged. Obliged.
Anyway, which is the paragraph, the main paragraph of the page?
My lord, it starts.
I know it's a very lengthy judgment.
My lord, it starts from the para 62 onwards, the discussions, my lord. Para 60, I'll just give the paragraphs, my lord,
Yes,
which will be relevant.
yes.
My lord, it's paragraph 2, 62, 65,
2, 62, 65,
78 to 81.
78 to
81,
78 to 81.
81, 78-81. Bless you. The length is because, my lord, it goes into the.
You see, one thing you'll have to clarify.
Well.
Why did you give extension after 7 years?
Yes, I'll clarify that. I'll clarify that. Yes. I'll clarify that. Yes.
And the wordings of one section 130A. There's scope for ambiguity, I mean, ambiguous interpretations. It's, though the second portion appears to clarify
The first portion.
the first portion.
That's why, my lord, I was trying to advance an argument that it is disjunctive. It's two
Huh?
different situations wherein, my lord, if it is not possible to do it within 1 year, because it was not contemplated at that point of time, the COVID would be over by 1 year. So the other part was brought in. My lord. If that is not there, because that is again wider, it says that this court, the government can go for any given situation, they can condone it and give an exemption. Now, in this cases, in one case, my lord, the exemption was given after in 2021 from March to September 2020.
2022.
No, my lord, the exemption was given in 21 from March 20 to September. What benefit, my lord, will happen? Then our argument would be, my lord, at that point of time, our resolutions were ready, but the government had not permitted us to hold it. So do they mean to say that that resolution is now, my lord?
That is another way of looking at it. This is supposing the COVID period got extended,
Lordship.
say for another 3-4 years. Then what would have been the
Situation.
yes? What would have been the validity or of that section 130? Would it die a natural death
Or
during that period? or what? So that is also another issue.
And my lord, if that view 130, if he says that the first paragraph and the other one is the same, then my lord, it comes into effect in 21. They give it effect from 5/3/20. So on the date it's notified, it's finished. For those societies who have completed. So that cannot be the idea of the legislature. Cannot be restricted.
You bring the records also, can you bring
Because the court has been
can you bring the discussions made with regard to this?
The statements and objects, my lord, if that is also placed before your lordship, my lord will have the records of what, my lord? The amendment,
The amendment of the section 130A,
why it was necessary.
how it was brought, how it was, made into law. What was the discussions that had gone into the making of this law? If you can, that will help us.
Lordship. And they, on this honorable court, on a number of occasions had called for that. But I'm
It's
I'm
not-
not sure
it's
it has
not-
not
it's
come
not
on
there.
board.
If it's not there, we'll have to do without it. We'll have to,
Interpret.
we have got to speculate, I guess.
I'll help my lord.
That way, the lawyers are the best. Very good. The number of, I think we should write a book, how to make adjournments and all this. We were part of it also.
Mine is 6 pay, my lord. My lord is keeping it part of.
I said on fourth,
Otherwise also.
depending if I'm giving the bench, if I'm not giving the bench.
That's why I said part of, my lord. If my lord is not given the bench, that part would come. Otherwise, my lord is here, then there is no problem.
I should be giving the bench. I don't want to, make it, it's a small issue, Mr.
My lord will say for further hearing, that much will do. Then we can handle it.
Okay, say for further here.
Much obliged. Obliged.
Please, Lordship, here is a case, my lord, we have filed this petition for recalling of the order passed by this honorable court. In respect of my lord, repetition, where my lord, the factual equivalent, I'm just placing the facts in nutshell manner. Well, the petition applicant is the owner of a particular plot, my lord, the premises, and it was rented out to the private respondent. Now, the term was, my lord, from 2019 to 2021, that was expired in the year 2021. Thereafter, we have repeatedly requested him to suppose vacate the premises. Neither he had paid any outstanding amount, nor that premises were vacated. Therefore, my lord, we have approached for the learned civil court for my lord filing a suit, and my lord also seeking certain, my lord, injunction order. The suit is now pending, and the next date is fixed on, my lord, 18/5/2023, my lord. Now, what happened, my lord? This is my clear case for one title.
So you're the owner,
Yes, I'm.
you're the respondent number 5.
My lord, title suit is pending. Both parties are there, and my lord, the next date is 18/5/2023, and
Title suit with regard to the
my lord, we
property.
have filed a title suit being honored for eviction against the, my lord, private respondent. He is the defendant thereon. Now, lordship, there is also injunction petition that we have. Now, suppose this order will remain in force, my injunction petition would be affected. Number one. Number two, they are saying about that the
How will
electricity
your injunction?
injunction we restrain them to suppose carry out certain activities in the premises and also
Huh?
restrain them to carry out certain activities in the premises because he is not the tenant as on that. He is a trespasser. Anyway, well, this is the civil suit which is now pending before the learned court below. Now, lordship, the core issue is what? They have approached before the FPDCL. Because prior to that, we have approached before FPDCL to disconnect the electricity connection that was done. After they approached before the FPDCL for reconnection. Now, that letter was rejected by the FPDCL on the count that they cannot allot a separate connection. Now, once it was rejected without challenging that particular order, they filed a writ petition before this honorable court. Now, in this writ petition, your lordship, on 29/2023, based on an order, this order was passed for reconnection. Lordship, kindly see page 41 for a moment of the writ petition. Page 41 of the writ petition. Madam.
Page 41.
Yes, madam, writ petition. Now, this is the letter, my lord, 13/2, out of which matter their prayer was rejected, and this letter has not been put under challenge in this instant writ petition. Regulatory commission.
No, how does it matter anyway?
Now, Lordship, second issue is that my kindly turn the next page, my lord. They have taken a support of a order passed by the Sonal
No,
Court.
no, so you're the read petitioner.
Respondent, my lord.
Huh?
I'm for the private respondent is lead petition.
You're the read petitioner.
My lord.
Huh. So,
My lord, I have been running the business there for my.
huh?
I have been running business, my lord, from the teenager to Mrs.
You have been,
Running business, my lord.
you're running a business.
Business, my lord. On 9/3/23, my lord, my landlady had filed an application for disconnection of power supply without any default in respect of payment of electricity charges, my lord.
Then,
Then on 9/3 itself, my lord, power supply was disconnected,
now, since there is a title suit between you,
my lord.
so.
That remedies can be invoked, my lord. They
Just
can-
a minute, just a minute. If there is a title suit between you,
That title
what
suit
is the necessity of having this writ petition here?
In petition, my lord, only I have paid for the restoration of power supply, my lord.
Power supply.
Power supply. That has been restored in terms of the order of the honorable arrest.
It has been restored.
Restored, my lord.
Then-
Temporarily, my
Huh?
lord. Temporarily.
So let it be restored in the time being that
My lord,
the,
in the meantime, they have initiated my eviction proceeding.
Huh?
If I am defaulter, I shall be evicted, my lord. Till then, my lord, I may be allowed to enjoy my property, my lord.
Correct.
To earn my livelihood. They are adopting all possible ways, my lord, to shut down my business activities, my lord.
Lordship kindly consider.
Which is
only
not
two points,
permissible.
my lord. Alternative remedies, they are civil suit. Apart from Lordship, suppose they agree.
yes,
with
there
this-
is, huh?
If they agree with this letter, my lord, appellant provision is also before the regulatory
Mr.
court, my
Counsel,
lord. That is
when,
also
when they have been given granted electricity, let them enjoy the electricity
My lord,
until you
next,
decide.
my lord, kindly.
Still eviction, my lord.
Lordship, kindly consider or two point, my lord, because I find this I. First thing is that my lord, civil suit is pending. If suppose any grievance, they can lay before the learned court below for seeking any injunction order, my lord.
Correct.
Now, Lordship, second thing is that they have annexed one order of CRP page 42. This CRP arising out of the title suit, my lord. Lordship, kindly see page 42.
Page 42.
Yes, there is CRP, my lord. The order which they have supported in their writ petition. It
Page
also
42.
42, my lord. Writ petition. There is CRP order, my lord.
I don't have, in the writ petition,
Writ petition.
or in the writ petition. The IA is thicker than the writ petition.
Writ petition, page, my lord, last
Yeah.
part. Now, this is arising out of a title suit dispute. The revision petition, there is a order. How a writ court can, my lord, take the singular views, my lord?
My lord, herein proposition of law was
Number
later,
one.
my lord.
Number
Therefore,
two, my
we had,
lord,
my lord, placed.
second point, my
That
lord.
that has been placed only, my lord.
Lordship,
Just a minute, this is not a fish market.
My lord.
Lordship, kindly. Both mixed will be the movement.
So in CRP also he has
Yes,
paid
my
for electrical connection.
exactly, my lord. Now, if suppose, kindly see, if suppose they oppose and they prayer will be rejected, then in a way of CRP, they may come before the honorable court. But they have filed a writ petition. My second point, my lord, if suppose this electricity
No, no.
proposal was
Just a minute.
My lord, that grievance can be dealt with by the separate form statutory bodies there in under my lord APDCL, which they have not invoked. State where they are coming to the writ petition, my lord. Alternative remedies in twofold are available, my lord. Then everybody will come, my lord. Nobody will go to the civil court, my lord. State where they file the writ petition, my lord.
What is this CRP filed? What is this CRP against what have you filed?
My lord.
This CRP has been filed against what?
No, my lord, in that case, that is different case, my lord, not connected to this case, my lord. That is the order passed in a different case, my lord, wherein, my lord, civil suit was pending. During pendency of the civil suit, repeatedly power supplies were disconnected, my lord. Then, my lord, injunction application was filed before the trial.
Same property,
No, no, my lord, different property.
It's a
different
reference,
issue,
my lord. It's a reference.
Different issue, my lord.
different,
This order-
different property.
Different property, different issue, my lord. Why, my lord, this
And,
order was annexed with the, it is
Just
just
an
to
example, my lord.
show the proposition of law, my lord. Just to show the proposition of law, my lord.
Now, lordship, alternative remedy kindly see
And my lord, there is no
against
more that my power supply has been disconnected by the, or upon the application of the landlady on the same day, my lord. On 9/3, my lord, CA filed an application for disconnection of my power supply. ACB state were disconnected my power supply.
Yes,
That, my lord, big appeal, I have come to the. before the ACC.
yes.
My lord, may I just? My lord, what has happened at the, in the writ petition, the annexure page 42, that is
Yes.
a different case altogether, my lord.
Okay.
The CRP is a case altogether. The petitioner here had applied for electricity connection for a separate meter as per the provision of 3.10. However, because there was in the premises, there was already a meter existed, we could not give him a meter. Thereafter, my lord, the petitioner here filed a writ petition. And as per the Supreme Court judgment, a temporary connection has to be given without the NOC. And accordingly, the single judge, the honorable judge of the High Court has passed an order, the temporary connection may be given. And we have restored the temporary connection. And as per due submission, my lord, 4.5.2, the format and the money and whatever the requisite has to be there. He has already been paid and has already been restored. So there is nothing from our end that we have done as per the law, and we have whatever the honorable court ordered us, we have given. And as per the law that exists here, my lord, that the temporary connection is a right of a person as of now.
Correct.
Yeah, so even if the civil dispute goes on and on, till the eviction, he has the right to enjoy the temporary connection.
Correct.
That is what I
That's
think.
correct.
lordship, only submission is that, my lord. If suppose he's a bona fide tenant, my lord, he has every right.
No, that is a bona fide tenant, illegal
No.
tenant, that will be decided by the
Exactly,
trial
my
court.
lord. Now, suppose if you want to take a electricity connection or other facility, my lord, civil suit is there.
No,
They
no,
can
no, no,
enforce
he's
their
been
money.
given, he's already, you see, Mr. Council, he's already been given a temporary connection. And there's nothing wrong with that.
My lord, temporary
So,
connection can be granted. no
Then
doubt.
I cannot help it.
My lord,
No.
kindly see that only one score is that, my lord, that if suppose there is a rejection from the, my lord, landed, my lord, again, a petition, suppose if they rejected the proposal. Lordship, I have given that regulatory bodies are there.
They have not rejected.
Rejected, my lord, page 41.
No, they have given a temporary, see,
No, my lord, page 41 kindly see, my lord, because there is a direction from this honorable court. that's why
Mr.
they-
Council, he wants, he's still tenant in that place.
No, absolutely not, my lord.
Till,
He is not a tenant.
until and unless he's evicted, they filed the eviction suit.
Lordship, kindly see, only Assam Tenancy Act, lordship, just only one line. my lord.
This is not a court which is going to decide whether he
Exactly,
should be
my lord. This
evicted or not.
disputed fact cannot be decided. Lordship, only one line, my lord. Tenant definition is given in under Assam Tenancy Act 2021 what? It is what? Just look for a moment, my lord. If they cannot take advantage, my lord, it's my property, my lord. 2.5, my lord, this is the law.
Grazie di somma di condizione. Ed è il 21.
So what is the cases pending?
What is the civil suit, the executive suit has been filed seeking.
What is the case number?
ES number, my lord, 184/23,
184 of 23.
3, my lord.
That is what kind of suit is that?
The ejectment and for relation of area rents.
For eviction,
Eviction and and realization of area rents,
and realization of
area rents
area rents.
with permanent injunction.
Permanent injunction. Before which court?
London Civil Judge number 2 at Guwahati,
Civil Judge
2 at Guwahati,
2,
2, my lord.
Guwahati. Guwahati or Guwahati?
Guwahati, my lord.
GU.
GUWA.
No, Lordship.
Along with the suit, my lord, one injunction application is also there.
Injunction.
Injunction
Whose
application.
application? His
His
application.
application, my lord.
So what is that? Any order passed?
My lord, upon injunction application, show cause notice was issued to me, my lord. Against issuance of show cause notice, the present petitioner has filed FAO, which was disposed of yesterday, my lord. Only yesterday that was disposed of, matter was remanded back to the trial court for deciding on 18/5. So, my lord, EJP suit is there, my eviction degree has been sought for, they have sought for realization of area rent.
My lord, they are not.
Whatever they are entitled, they will get it in their suit, my lord. Why am I disconnection?
Under, it is a new act, my lord, Assam Tenancy Act 2021.
That had not yet come brought on record, that is not brought.
Assam,
applicable.
we have mentioned,
Rules-
Assam Tenancy
rules
Act
has not been
2021, my lord, Kali 2 and say, tenant whether called lessee or by any other name means a person by whom or whose account or on behalf of whom the rent any premises payable to the landlord under a tenancy agreement. But there is no tenancy agreement.
Mr. Council, those issues, whether you are, whether he is a tenant liable to be evicted will be
My-
decided by the,
Exactly.
will be decided by the civil court.
Let them approach for a civil court.
No, why? You have already gone. That's
My lord,
already pending.
suppose they want any relief, my lord.
No,
Civil
no,
court is
so,
not
so
department.
now he doesn't want any relief.
My lord,
He has got the relief of electricity. That's all he wants.
my lord, in my case, they can also apply for injunction, but
Why?
our read court
Why?
will deal with the private dispute, my lord. That is clear.
So
that-
what is your case? Your case is that his electricity should be say, disconnected. Is that your case?
No,
This is
no.
not your writ petition.
No,
In their read petition, my lord.
No, no, Mr. Council,
Yes,
their writ petition is to get a connection.
yes,
My lord.
sir.
They have got it.
yes.
Now, what is your case? That they should not get a they should not get an electrical connection? What
no,
is
that
your
is not
case
my
in this
case.
writ
My
petition?
lord, that is not my case.
What is your case?
My case is that the read petition outright is not maintainable because two count. The application which has been rejected by APDCL against which my appellate provision is available before the APDCL.
No, no, now he has got electricity.
Now,
He doesn't
second
want
point,
it.
my lord, civil suit is pending where the both parties disputes are there. In between, my lord, this kind of order will affects my rights, my lord. Property rights, my lord.
What right effect, my lord? He has already
No,
filed.
no, we will clarify that the allotment of the temporary connection to the writ petitioner will in no way prejudice the rights of the petitioner, rights of the landlord in the title suit. That's all.
My lord.
My lord,
That's all.
My lord, that's-
nah,
This is,
we cannot say
because
what
this
my
writ
lord-
petition is only with regard to electricity. And
And that's why
as per the judgment of the apex court,
apex court, my lord.
uh,
Para nine.
electricity is a basic amenity
Yes,
of which a person cannot be deprived.
but to whom?
Electricity cannot be declined to a tenant on the ground of failure refusal of the landlord to issue a no objection certificate.
Absolutely, my lord. Tenant. He is not a tenant as on that. Lordship,
So
that's
that will be decided.
I have not given my lord, why for ejected.
My lord,
Right.
let him say that.
Okay, right, right, in the IA. This is an application filed by the applicant slash respondent number. Respondent number
4, my lord.
4 in the writ petition. To set aside the order dated 29/3/2023.
Sorry, ma'am, that's point number 5, my lord.
That's point number 5. 29/3/23. Passed in WPC 173 of 2023. Yes, sir.
1773, my lord.
Huh?
1773,
1773 of 2023.
my lord, my lord.
Yes, sir. The respondent number 5. Now, the writ petitioner is a tenant, he claims to be a tenant. under the respondent number 5. Full stop. However, due to some dispute regarding payment of rent, comma, the respondent number 5 applied to the APDCL authorities by letter dated 9/3/2023 for temporary disconnection of electricity of the premises which was let out to the petitioner. The said application being acted upon by the APDCL, electricity was disconnected from the premises occupied by the writ petitioner, which is, comma, which is being used as a restaurant. Full stop. Next para. The writ petitioner thereafter approached this court, and this court by order dated 29/3/2023 directed the petitioner to submit an application for a temporary electrical connection. For temporary electric connection. Full stop. The connection was thereafter, the electric connection was thereafter provided by the APD. The temporary electrical connection was thereafter provided by the APDCL to the writ petition. Full stop. Next para. The grievance of the applicant / respondent number 5 is that the writ petitioner is not a tenant of the respondent number 5. Further, after the electricity had been disconnected to the premises occupied by the writ petitioner, comma, the writ petitioner had made an application to the APDCL authorities for a separate electrical connection. Full stop. However, the APDCL authorities had rejected the writ petitioner's application on the ground that electrical connection having already been given for the said premises in the name of the respondent number 5, comma, a second electrical connection could not be given to any other person.
Under clause 3.10.2
Under clause 3.10.2
of the AERC code. AERC code. AERC code.
of the
AERC. Assam Electricity Supply Code. AERC
Assam Electricity
Regulation Supply Code.
Regular, you got it?
AERC. Yes.
Full stop. The counsel for next para, the counsel for the respondent number 5 submits that the writ petitioner should have approached the appellate authority for against the order dated. What is the order that was that this?
29.
My lord, the order is that in the IA at page 21.
No, in the writ petition that was where electrical connection was not allowed.
My lord, that is at page 41.
Should have
13 to 23, my lord.
30 to 23, page 41.
submit that the petitioner should have filed an appeal against the order dated 13/2/2023 and should not have approached this writ court. First up, he accordingly submits that as there is an alternative remedy available for getting a connection by for filing an appeal against the order dated 13/2/2023, the writ petition, the interim order passed on 29/3/2023 should be set aside.
That is,
Full stop. Next para. The learned counsel for the respondent number 5 applicant / respondent number 5 further submits that a title suit submit that title suit number 184/2023 has been filed by the applicant respondent number 5 before the court of the civil judge 2 Guwahati, praying for eviction and realization of arrears of rent from the writ petitioner. He also submits that. No, he thus submits that if the writ petitioner was having any grievance with regard to electricity connection, he could have made an application before the learned trial court. Full stop. Next para. Mr.
SP Sharma, my lord.
SP Sharma, the learned counsel for the APDC, submits that electricity is a basic amenity which cannot be deprived. Now, from which a person cannot be deprived, even though he is a tenant, as has been laid down by the apex court in the so and so, reported in 2022, SCC online, SC 810. He also submits that a temporary connection has already been, electricity connection has already been given to the premises occupied by the writ petitioner. And as such, there is nothing left to decide in the present writ petition, correct? That's all.
My lord, his entire contention of the present writ petition was that he should get a separate electric meter as per 3.10. However, that cannot be given. So that's
stop.
why the honorable court said that
Yes.
because electricity is your right,
So
we will give you temporary
Full stop.
connection.
he further submits that, he submits that, though the writ petitioner had applied for a permanent electricity connection
Under 3.10.
under 3.10.2
Point two.
of the so and so, comma,
He-
the petitioner was not entitled to the same and entitled to same. Full stop. However, in view of the judgment of the apex court in Dilip dead Supra, the petitioner has been Supreme Court in Dilip dead Supra, and the order dated 29/3/2023 passed by this court, a temporary connection has been given to the petitioner. Full stop. Next paragraph. I have heard the learned counsels for the parties. Full stop. In the case of so and so, Supra, the apex court has held that it is a settled proposition of law. It is a well settled proposition of law that electricity is a basic amenity of which a person cannot be deprived. Full stop. It further held that electricity cannot be declined to a tenant on the ground of failure / refusal of the landlord to issue no objection certificate. Full stop. All that the electricity supply authority is required to examine is whether the applicant for electricity connection is in occupation of the premises in question. Full stop. Next paragraph. The law laid down by the apex court in Dilip dead Supra clearly goes to show that a person in occupation of a premise / building could not be deprived of an electricity connection. Full stop. In that view of the matter, now it's a full stop, as it is an undisputed fact that the writ petitioner is in occupation of the premises, which is the subject matter of dispute, in title suit number 184/2023 before the court of the civil judge to Guwahati, comma. This court does not find any infirmity with the order dated 29/3/2023 passed by this court. Doesn't just say does not find any infirmity, just say does not find any ground to modify, comma, vacate or set aside the order dated 29/3/2023. As the Standing Council of the APDCL has stated that electricity has been provided to the writ petitioner, comma. Nothing further requires to be adjudicated in the writ petition. Full stop. The dispute with regard to whether the writ petitioner is to be evicted or is as to whether the writ petitioner is a tenant who is liable to pay rent and is to be evicted, being already being an issue to be decided by the learned trial court, comma. This court is of the view that the present writ petition can be closed as on date. Full stop. The writ petition is accordingly, the IA is accordingly, dismissed. Dismissed. Next para. In the main case, right, in view of the order passed in IA, in view of the order dated today, passed in IA 999 of 2023, the writ petition is also accordingly disposed of.
My lord, the power supply may be allowed to be continued till disposal of the school, my lord.
It is made clear that the in the IA, right, it is made clear that till title suit number 184/2023 is decided, the temporary power connection provided to the writ petitioner's premises should continue, subject to payment,
My lord, subject to payment of all charges,
subject to payment of all
all
charges.
charges.
My lord, may only one submission, my lord. If suppose this will give a, my lord, order, then it ultimately, my lord, years to year, my lord, they will enjoy only by paying but they will not pay any rent to me, my lord. Lord,
My
what
lord,
is the necessity of?
You said that he's not a tenant.
My lord, till disposal, my lord, this is not the case, my lord, I have filed IA. In
What
IA,
I- my lord, says I am not-
at base may not suppose interfere with, my lord.
You
But
see,
if suppose to pass this order, then ultimately the 10 years, my lord, if suppose that should be pending, my lord, then what happened to my property, lord? Can you also make?
you go to the trial court.
my lord, in the
And
trial
you
court, my lord. he has
You
paid
can
for-
apply
Yes,
there
my
in the
lord,
trial
that's
court.
why-
You have applied for
My
10.
lord, already, my lord, paid. for-
Look, in the trial court, what have you prayed for? You have prayed for realization of rent.
No, my
Rent
lord.
till eviction, my lord.
No, my lord, lordship.
Till
Actually,
eviction.
I cannot make submission because there is a close submission, but they got two stories continuing, my lord. Lordship, can you give me a little time to make my case, my lord? Question is that, my lord, title should be spending, no doubt, my lord. If suppose lordship pass this order that till disposal, my lord, then this is neither their prayer nor my prayer, my lord.
Don't say till disposal, till
It is not their prayer, my prayer.
till such orders are passed by the
Trial court, my lord.
till such orders are passed by the trial court and any other appropriate authority.
No, my lord, then, my lord, they will file an application before the trial court for destination, my lord. Then.
They will do that, let them do. What is that? They don't have, for you,
No, my lord, they have filed suit, my lord, they paid for.
My lord,
it.
kindly
Rent,
see, my lord,
by
not a
eviction, my lord.
single, lordship,
Whatever they are entitled, they will
They-
get, my lord. from the
I have
trial court.
already passed an order that till you pay your charges.
Why not?
So how does, so that, let them file, how does it?
Till disposal of the suit, that will be satisfied, my lord. Because I have to pay, my lord, for
my
enjoyment
lord,
of the electricity.
kindly see, my lord.
Next, I'll pass. Let me see.
Much obliged.
Both disposal.
So in that petition, I am praying for release the admitted amount, which has been admitted by the respondent authority in their affidavit also.
Please, your lordship, reply on behalf of Mr. N. Upadhyay. Some urgency, personal difficulty, lordship, he left his support.
Who?
Sometime. Mr. N. Upadhyay, attending as a litigation lordship. He informed me to mention before your
Lordship. So Lordship will then take it up immediately after vacation, Lordship.
On the prayer for adjournment, no. Made on behalf of Mr. N. Upadhyay, Learned Counsel for the Irrigation Department,
Very good.
who had to suddenly leave the court premises, list the matter on, give a date. Anytime. Basically, he wants a date, that's all.
Lordship, what shall we?
On behalf of the MS U Chakraborty, I am paying
Item
for the
15?
U Chakraborty. I am paying for the adjournment of the matter, item number 15 and 16.
Okay, adjournment or matter just give me the phone. They pray for adjournment.
Yes, Lord. So the outgoing
Okay.
council is in
On the prayer for adjournment made on behalf of Mr.
MS U Chakraborty. U Chakraborty.
Miss U Chakrabarti.
Yes.
Learned Counsel for the applicant, this is the matter. After 2 weeks.
Hello. Item number 16 also paying for.
Okay, same one. Yes, just show me that last order. Just let me see what it is. Yes. You see, Mr. Counsel. You are appearing for whom?
I am instructed by Mr. MS U Chakraborty.
Who are they?
I think he is the railway standing council.
Railway standing council. Now you see the problem that has occurred here. Is that all the 3 respondents have passed away. What is to be done?
I think. As I am not associated with the case also, so he's just instructed me to take on.
Naturally instructed you because of this problem. This IA has been filed in the year 2017
Lordships,
and the last order was passed on January 23. Wherein Miss M. Chatterjee was asked to file appropriate petition for substitution.
Mayor Samit.
Yes.
Lordship, MS U Chakraborty, actually he is in a hospital in Delhi now. And M Chatterjee is in her daughter. Both are in outside of the body. And they are instructed over telephonic to me, take just adjournment of the matter. I will convey this.
You tell them next time they don't come, we're dismissing this case.
Lordship.
And they have got to file application, right?
Okay.
What is your name?
Mr. MR Islam.
Mr. M.R. Islam submits, prays for adjournment on behalf of Miss U Chakrabarti, Learned Counsel for the applicant. The order dated 9/1/2023 states that the respondent numbers 1, 2, and 3 have passed away. And Miss M. Chatterjee, the Learned Counsel for the applicant, was granted 3 weeks time to file appropriate petition for substitution. However, no such application has been submitted till date. In view of the prayer made for adjournment, come on, list the matter on, give a date.
Hello, heart of me. Hello.
The applicant shall submit application for substitution of the respondents by the next day.
Lordships, can we attend another week because he is in a hospital now? Maybe it's a short time.
Who is in hospital?
U Chakravarti.
M Chatterjee can come.
Lordship, government also there, Lordship, respondent number 4. So it was reflected from
Union of India is the party.
Lordship.
Respondent 4 is of hardly any use. 1 to 3 are the most important.
Lordship.
They've got nothing to do. 4 is just collector, he's a performer respondent.
Performer respondent.
4 is of no use.
Please, your Lordship. There are delay condemnation application in respect of the land acquisition appeals. Lord.
Yes,
There were 49.
any
appeals.
objection?
No.
No objection.
Lord, delay have been condoned in other matters, Lord.
Yes, so we condoning, he says no objection. Heard, mister?
R Dugan.
Your name is not here.
Lord, I am the standing counsel for airport authorities, Lord.
Huh?
I am the standing counsel, Lord. I have been
Airport.
assigned this case.
Okay, Mr. R. Dubey, learned counsel for the applicant. Submits that there has been a delay of 221 days in preferring the connected LA appeal against the judgment and decree dated 30/05/2015 and 4/12/2015 passed by the learned additional district judge, number 1, Kamrup M, Guwahati, in reference case number 196/2001 arising out of LA case number 27/1995. Full stop. Mr.
Yan Burwa,
N. Barua appearing for
on MD Chaudhary,
N. B. Chowdhury. Counsel for
Private respondent.
private respondent.
private respondent. How many private respondents? One.
Yes.
For respondent number 1.
Two, Lordship.
And who is for the revenue department? Huh?
1 and 2.
No, 2 is revenue department, Mr. Counsel. Miss N. Bordoloy. Acha, 1.
One is Parag Chandra Das and 2 is Kiran Das.
No. Peter, 3397.
Item number 18.
Which IA are you talking about? Give me the IA 372 also. Give me all the IAs. Let me see all the IAs. Give me IA 2034 also. Yes. Who is the respondent name? Out here is Bhagi Ram Kakati.
Yes, Lordship, 1.
That is what you gave some other name. And 2 is, I think, 2 is revenue.
Revenue. correct.
17, I am for respondent number 2.
Yes, Miss N. Bordoloy for respondent number 2 and district collector
TR Gogoi, Lordship.
and Mr. T. R. Gogoi, learned counsel for the respondent number 3.
Lordship.
Submit that they have no objection to the delay being condoned. Full stop. Next para. On perusing the reasons for the delay provided in the application and keeping in view the submissions made by the council for the respondents, this court finds that sufficient cause for the delay has been made out. So accordingly, the delay of 221 days in filing the appeal is condoned. I is accordingly disposed of. Okay, then. Acha, before that, you disposed of before that. Registry to register the appeal. And list the same accordingly after a week.
Lord, because it will come for adjournment. Already similar matters have been fixed on 27.
List the matter on 27th.
Could it be listed before that, Lord, 21st second? Because other matters have been admitted and fixed for final hearing.
Okay, list the matter on
21st.
21/4. What about the IA, this IA for stay?
Lord, the matter will be taken up for the final hearing.
Correct,
Therefore, at
correct.
this stage,
That's fine.
let it be pending.
Lordship, there is one another.
But just a minute, item 18, so we can do it. Give me item 18.
Yes.
Item 18 we can do, item 18 already there. So item 18 we can admit. Item 18, the I also. In, no, item 18 has already been admitted. 18 has already been admitted. Give me the IA.
He has already admitted.
IA is 2034, give me that. What is this? Application for, we'll state the judgment in order. What is it? It is
Not
stated.
required, my lord, because in other cases we have not pressed for. It has already been fixed, my lord, in other matters, my lord.
Okay, then no need. No order. So then next item. Yes, madam, notice was issued only on 23/3.
Yes, my lord, I have taken steps, my lord. And the
So,
office note.
so
is-
not even 1 month has passed, so we have to wait,
Yes, my lord.
right? Office note indicates that notice was issued. To the respondent. On 23/3/2023. Full stop. There is no return of any card or unserved notice. Full stop. As. No, as such, comma, await service report.
Yes.
This is the matter after 2 weeks.
Obliged.
Finish. Somehow got through the day. I'm having severe back pain. That's right.
Feeling well or not today, Lordship?
No, I had severe back pain.
Severe then.
So I thought I might not come out. Last night, 2:33, I got up. This morning I had painkillers and all.
Possibly then
Then I
take
came.
rest, Lordship, otherwise.
So I went to the hospital also during.
We are noticing
Afternoon.
today beginning from beginning, Lordship.
Huh?
We are noticing you today from beginning, Lordship.
Acha,
Lordship.
it shows on my face.
No, Lordship, just.
Oh, okay. Happy Bihu.